Good morning, everyone. Thank you for taking time to access this online webinar discussing irrecoverable damages. This is an interesting and increasingly important area in clinical negligence litigation, both from a claimant and defendant's perspective. And it's often very easy to overlook questions of quantum in cases. Seminars and lectures are more often drawn to interesting questions about causation and the extent or otherwise of the duty of care. But assessing damages is very much the bread and butter of the vast majority of cases which you as claimant or defendant solicitors will be looking at. So I thought it would be worthwhile coming back to the question of irrecoverable damages and to provide some assistance to you in doing so. So just as an overview of this talk, we'll discuss the principles underlying the award of damages in tort law. We'll look at the proof of loss and cases of a loss of chance, the principles used to limit compensatory loss, cases of pure economic loss. We'll look at some common areas of challenge and some contentious heads of loss. And then I just wanted to end by looking at surrogacy claims as well, which are very interesting, especially as regards to the quantum aspect of the same. Okay, so compensatory damages. I don't want to revert to basic tort law, but when grappling with difficult questions, it's an age-old adage that you should start at the beginning. So let's actually look at compensatory damages, what they are and what they intend to achieve. So compensation means the award of money which is equivalent to the claimant's loss. The losses can either be pecuniary or non-pecuniary. The fundamental distinction between pecuniary and non-pecuniary loss is that money can completely compensate for the former but not the latter. So consider the distinction in terms of losses which are of wealth and those which are not. A loss of wealth can be translated into money and therefore is a pecuniary loss. For example, if you are claiming for the cost of glasses, that is a pecuniary loss. Factual causation. The claimant must establish that but for the breach, the loss would not have been incurred. This sounds very obvious, but it can be very complicated in many cases. The vast majority of cases will be considered on the traditional but-for analysis. It's beyond the scope of this talk to consider instances of material contribution in any great detail. So just looking at factual causation, I wanted to raise an interesting area which is very common in schedules and counter schedules, which is what's the situation where effectively the claimant suffers an injury upon an injury. Dealing with clinical negligence, it's trite that the reason why an individual presents to a hospital in almost all circumstances, apart from maybe elective cosmetic surgery, is that there is something wrong with them. It could be very minor or it could be very serious, but they are in a position whereby they need the input of medical expertise. So if there's an injury upon an injury, that is not particularly uncommon. And consider the case of Rini and University Hospital of North Staffordshire. It's a well-known case, and it's well worth reading in its entirety. Has an excellent, in the Court of Appeal, analysis of causation and summary, but it deals clearly with these types of instances. So the claimant was in Rini, the claimant was admitted to hospital. The claimant, pre-existing, was already paralysed from the waist down. Whilst she was in hospital, she suffered a grade 4 pressure sore, and that greatly increased her care needs. In the High Court, Mr. Justice Foskett, he applied the but-for test inconsistently, and he allowed the care in full. That was overturned and reversed in the Court of Appeal, and the Court of Appeal held that the NHS Trust was only liable for the increase in care needs, and the importance is the difference between a quantitative difference in care needs, i.e. the claimant needs more of the same type of care, and qualitative difference in care needs. So simply because the claimant needs more of the same doesn't mean that the defendant will be liable for the entirety of the care package. However, if the negligence results in a qualitative difference of care, then they will be. That's something which is often seen in cases, and it's easily overlooked. Okay, proof of loss. Uncertainties about a past fact is determined on the balance of probabilities, and that was well explained and laid out by Lord Diplock in the decision of Mallet, where his lordship said, in determining what happened in the past, a court decides on the balance of probabilities. Anything that is more probable than not, it treats as certain, but in assessing damages which depend upon its view as to what will happen in the future or would have happened in the future if something had not happened in the past, the court must make an estimate as to what the chances of that particular thing will or would have happened, and reflect those chances, whether they are more or less than even in the amount of damages which it awards. So what Lord Diplock is saying there is, if you're looking at past, you have to look on the balance of probabilities. Is it more probable than not that X or Y would have happened? But in assessing damages which are looking in the future, the court must make an estimate as to the chances of that particular thing happening. And we'll come on to that in a little bit more detail when we look at loss of chance claims. So a loss of chance was considered in the two High Court House of Lords decisions that you'll all be familiar with, which is that of Hodson and East Berkshire Health Authority and Gregg and Scott. And those decisions confirm that damages will only be awarded where there is an above 50% chance of a hypothetical event materializing. It's an all or nothing approach, which is at odds with other areas of damages, such as loss of profit in contract claims. Once the claimant has established an actionable personal injury, effectively causation has been satisfied, uncertainties as to the claimant's future are considered on a proportionate basis. So what that means, going back to what Lord Diplock said, is that once it's been determined about the injury, so but for the negligence, X, looking to the future, you must look at it proportionately. So I've included on the PowerPoint 3 example cases here, which illustrate the point very nicely. There's Doyle and Wallace and where the court said that there was a 50-50 chance of the claimant becoming a teacher. So the Court of Appeal awarded 50% of the damages to represent 50% of that chance. The decision in Langford and Hebron, where the court assessed loss of earnings that the claimant would have been a professional kickboxer. There were three possible scenarios that had been put forward with differing probabilities, and that approach was accepted as correct by the court. And then finally, Brown and Ministry of Defence, where it was accepted that there was a 30% chance of the claimant completing 22 years of service within the military, and therefore entitling them to a pension. Looking then at the claimant's hypothetical conduct, the hypothetical conduct of the claimant is not considered on a proportionate basis. The claimant must establish this on the balance of probabilities. So this is well known in the leading decision of Allied Maples Group and Simmons and Simmons, which was a professional negligence case involving the defendant firm of solicitors. The Court of Appeal held that the claimant must demonstrate what his actions would have been but for the breach on the balance of probabilities. And this again is an area which you will often find in clinical negligence cases and the claims for damages. And I certainly find this in relation to future medical treatment which is claimed by the claimant. A good example is the future cost of prosthetic limbs. The claimant must demonstrate that they will utilise the limbs, and they must do so on the balance of probabilities because it is effectively hypothetical. So if you've got your claimant hat on, make sure that you are satisfied that you can reach that threshold. If you're looking at this case from a defendant's perspective, consider questions such as, is the claimant physically able to make use of the prosthetic limb? Learning to use prosthetics requires a great deal of time commitment and motivation. I've seen cases where the claimant effectively has accepted that they would not be able to, or have had the inclination to learn to use the limb. Also look to see, has the claimant consistently acted upon the advice of the medics? If you're presented with a case where the claimant says that they would have done X, will do X, either they will obtain a prosthetic limb, or they will undertake CBT treatment, or they will attend physiotherapy. If the claimant's clinical records are littered with instances of the claimant failing to follow medical advice, it's going to be more of a challenge to persuade a court that hypothetically, on the balance of probabilities, the claimant will elect and make use of the medical treatment that has been sought. And as we all know, future medical treatment can be a very costly area of the schedule of loss. Also consider other factors which would or would not indicate whether or not the claimant would utilise treatment. For example, going back to the prosthetic limb, if the claimant's an 85-year-old individual with COPD, is it really likely that he or she would make use of a below-knee prosthetic limb? You've got the age to consider. Also, the pre-existing COPD. Is that likely? Right, let's look at pure economic loss now. This is an area which seems to really scare tort lawyers because it's often said, well, pure economic loss is a question of contract and commercial litigation, but there's no need to be particularly put off by the issue. So a pure economic loss is an economic loss that is not immediately consequent on physical damage. The situations of pure economic loss will be rare in tort cases and in clinical negligence cases particularly, because the claimant will have suffered a physical harm. But it is important to analyse the loss claim to determine if that loss was consequent on the physical damage. That is the important point. So consider this example. The claimant suffers a stillbirth and it's negligent. Negligence is admitted. She brings a claim. The claimant's off work because of the psychiatric harm which she suffered, and contained in the schedule of loss is a claim for the loss of rental income from a property that she owned. The claimant alleges that it was necessary to sell the property as she could not work. So we have a situation where negligence, loss of rent because she said they had to sell the property due to her inability to work. Ask yourself the question, is that loss consequent of the physical damage which she suffered? I'd probably say no, it's not. The loss is related to her inability, to work. So I'd say that is an example of a pure economic loss. Now, one area which you'll all be aware of where economic loss did arise as relates to clinical negligence cases was the wrongful birth claims, starting with the decision of McFarlane. So in that case, the House of Lords held that the mother's pecuniary and non-pecuniary losses directly consequent on the pregnancy and the giving of birth were recoverable. They were regarded as equivalent to personal injury losses, but they held that she could not recover for the economic cost of the child, as that was considered to be a pure economic loss. We have the decision in Parkinson and St James and Seacroft University Hospital, and that involved a disabled child, still a wrongful birth claim obviously, and the court awarded the cost of upbringing attributable to the disability. And then we have the decision in Rees and Darlington, which involved the mother was disabled, and effectively a bit of a gloss was placed upon this, on McFarlane, and an award of £15,000 was made to reflect the fact that there was an unwanted birth and that was attributable to a civil wrong. So if you find yourself faced with a pure economic loss, or a case that you think might be pure economic loss, you have to look very carefully at what the loss is that's being claimed, and you must look to see if that is actually consequent upon the physical harm which has been suffered by the claimant. If you think that it's not, then you might be looking at a pure economic loss case, and then you will go from there. But if it's clear that what is being claimed is consequent on the harm, care, for example, that's not a pure economic loss. So let's look then at another area, illegality and public policy. Again, like cases of pure economic loss, they're going to be few and far between, and they're usually going to be pretty self-evident when you see them, either as a claimant or as a defendant. Let's just consider, though, a couple of examples to try and flesh this out a bit more. So the claimant suffers from PTSD as a result of negligent surgery. The claimant assaults X and ends up in prison. The claimant brings a claim for a loss of reputation resulting from being in prison. I don't think anyone would seriously contend that the court would entertain such a claim. But consider this, though, much more nuanced example. Negligent surgery again, and the claimant suffers PTSD and becomes an alcoholic as a result of his PTSD. He brings a claim for the cost of the alcohol. Should he be entitled to recover? So we have factually negligent surgery, PTSD, alcoholic, cost. Some people may be tempted to say that that is a loss which is consequent on the physical injury, but would the court entertain such a claim within a schedule of loss? In answering that, there's some very useful guidance from Lord Justice Laws in the decision of Rahman, where he said, so in all these cases, the real question is, what is the damage for which the defendant under consideration should be held responsible? The nature of his duty, here the common law duty of care, is relevant. Causation will certainly be relevant, but it will fail to be viewed and in truth can only be understood in light of the answer to the question, from what kind of harm was it that the defendant's duty to guard the claimant? So Lord Justice Laws is talking about, obviously, responsibility of the defendant and what was their duty to guard the claimant against. So in answering the second example that I gave you of the alcohol, no, the court would not award for something dysfunctional like alcohol. What they would do is there would be a finding, most likely, that the fact that he was an alcoholic is reflected in an increased PSLA award and potentially loss of earnings if he could no longer work. Come on to that again when we talk about surrogacy cases as well. So let's look then at the principles which limit compensatory damages. These are all well known, but again, they're well worth reviewing. So the principles that limit compensatory damages are remoteness, mitigation, an intervening cause, and contributory negligence. Torts which are actionable only on proof of damage, such as negligence, obviously, the question of remoteness and intervening cause are often concerned with whether a tort has been committed, effectively liability. But they also serve to limit the damages and compensatory damages when you assess individual heads of loss. The courts, again, when you read the cases around this area, they often don't draw a distinction between remoteness and intervening cause. Usually, and certainly in the older cases, they will speak of legal causation. This can cause confusion, but both principles are going to the same policy, and this was made clear by Lord Wright in the Liesbach, an old and very famous case, where his lordship said, the law cannot take account of everything that follows a wrongful act. it regards some subsequent matters as outside the scope of its selection. In the varied web of affairs, the law must abstract some consequences as relevant, not perhaps on the ground of pure logic, but simply for practical reasons. So remoteness is a principal restriction on compensatory damage, is that, as you will all know, a loss must not be too remote, as it's phrased. Note that there is a distinction between contract, where the loss must have been reasonably contemplated, and tort, where the loss must be reasonably foreseeable. The policy reason behind remoteness is very clear and well understood, is that it's unfair to the defendant, and it imposes too great a burden to hold them responsible for losses that could not be reasonably foreseen. Now, the Wagamount is the old and leading decision on remoteness and reasonable foreseeability, and as you will all know, it was the new test that it gave rise to of reasonable foreseeability, and overruled the old approach of, in the case of Repolmis, which the old approach was that the defendant would be liable for all direct consequences of the negligence. But the Privy Council overruled this in the Wagamount and introduced the new approach of reasonable foreseeability. Now, in the Wagamount itself, the Privy Council held that whilst it was foreseeable that damage could have been caused to the wharf by the oil spill, they could not reasonably have foreseen that the damage could have been caused by fire, and that was the important distinction. So there are 5 features that are worth considering in this area. The first is that so long as the type of physical damage which resulted was reasonably foreseeable at the time of the negligence, neither the actual manner in which it came about or the actual extent needs to be considered to be reasonably foreseeable. And that was best illustrated by the decision in Hughes and Lord Advocate, which again is a very well-known case, but the decision in Hughes involved a child playing with a gas lamp, and the child tripped and the lamp fell into the hole, the excavation, which caused an explosion and burnt the child. The defendant was held liable. And now the court said that whilst the sequence of events was not foreseeable, the fact that the child might be burnt playing with a gas lamp was foreseeable. It did not matter that the burns were more serious than those which were reasonably foreseeable. So effectively, because it was foreseeable that the child playing with a gas lamp could be burnt, it didn't matter that the burns resulted from the explosion. So it's the actual manner in which the tort came about is the important point there. Second, the notion that it is the type of physical damage that needs to be reasonably foreseeable allows the court considerable discretion in how wide to extend the defendant's liability. Third, the eggshell skull principle survives, and I've included for you in the PowerPoint the decision of Smith and Leach, which involved negligently inflicted burn on a lip resulted in the claimant's husband dying of cancer because he was resulting from pre-malignant cancer. So the eggshell skull rule survives. 4, it's no bar to recovery that the losses are far greater than could be reasonably foreseen. Again, Hughes and Lord Advocate is a good example of that. And 5, the degree of likelihood is low. It was said in the Wagamount, number 2, resulted in the test of foreseeability being a possibility as opposed to a probability. And that's quite an important point, that it's possibility, not probability. Let's look then at some common areas of concern, which again you'll find day in, day out in schedules and counter schedules. We've already touched upon medical treatment earlier, but it's well known, obviously, that a claimant is entitled to the cost of medical and nursing treatment by virtue of the Law Reform Personal Injuries Act 1948, Section 2, Subsection 4. The claimant will not be entitled to the private costs if they utilise the NHS, and again that's well known. But think again, and this is something that I do often see, is that a claimant will be receiving treatment on the NHS. Diabetes type cases is often a good example of this. They receive regular and routine treatment on the NHS, and there is a claim presented for the cost of that being on a private basis. You have to go back to look, as we were talking about earlier, evidentially, will the claimant satisfy the court that he or she would undertake this on a private basis? From a personal perspective, I think more often than not, no, because it's difficult to persuade a court that a claimant is going to radically change their medical treatment, because the vast majority of claimants don't want to. If they are seeing an NHS consultant on a regular basis for treatment of whatever, more often than not, they're not going to want to change. Also bear in mind whether or not there needs to be a multidisciplinary approach to treatment. NHS hospitals are far better equipped, notwithstanding resource pressures, for that. Again, diabetes is a good example of such cases. Another area of particular controversy is gratuitous care and assistance. Now, whilst, as is well known, you are entitled as a claimant to claim for gratuitous care and assistance, you have to remember and bear in mind that the loss is not, in fact, the claimant's loss. The loss is the third parties, as was made clear by the decision in Hunt and Severs. Technically, as a legal mechanism, it's held on trust. But from a defendant's perspective, and you should be mindful of this as well from the claimants, is the claimant producing evidence to demonstrate that there is intention to fulfil the terms of the trust? It is not an opportunity to inflate the value of a claim. And also, as regards gratuitous care, it often is in relation to cooking, cleaning, so on and so forth. Ask yourself very much, what was the claimant's position before the negligence? What is the claimant's position afterwards? If the claimant before did very little around the house and after continues to do very little, where is the loss? Gratuitous work as well can be an area of controversy, and I've included the decision of Hardwick, which is interesting. The claimant claimed for a gratuitous clerical work provided his wife. The decision to utilise the wife was commercially motivated, i.e. the loss was therefore too remote. Cancelled holidays, weddings, so on and so forth. Often see these in schedules. Look to see whether or not these are too remote again. Was it reasonably foreseeable that the holiday wedding would be cancelled? Is it likely that the damage will be reasonably foreseeable but for the loss? Have seen this in a few cases, losses which are consequent on a divorce, and then the decision of Pritchard is quite well known, where the court held that whilst the divorce was foreseeable, the pecuniary loss was irrecoverable, and that was about a family business and the losses which arose from that. Okay, looking then, it's well worth revisiting the old and well-known Latin maxim of restitutio in integrum, and what that is restoring the claimant to their original position, and it's the crux of compensatory loss. There can be difficulty, and I have seen this increasingly actually, where the claimant is claiming for items which they did not use before. Now, some of them will be very obvious. If you never needed a walking stick, but you now need a walking stick, that's understandable and not controversial. But consider the following examples. A claimant that claims the cost of a car when they previously used the bus. A claimant that claims the cost of an expensive holiday when previously the evidence was they never went away. The claimant that cannot play golf, therefore goes away on a cruise holiday. Consider the case of a claimant that's disabled and housebound as a result of the negligence, so purchases Sky TV. You have to step back and consider that is the head of loss that's being sought seeking to restore the claimant to the original position, or is the head of loss that's being sought really moving beyond that into an instance effectively where the claimant's placed into a better position as a result of the compensation? In these cases, there very much can be too much of a focus on factual causation, cause and effect. I think much better is for the parties to assess whether or not the loss is restorative. The frustration that the claimant feels for not being able to play golf or being housebound, that goes to general damages. The fact that they can't do something, i.e. play golf, does not mean that they have a right to claim for a cruise. So it's important to remember it's the loss of amenity aspect of PSLA that comes into play there. Right, I just wanted to consider surrogacy claims with you, which are a very interesting area and seem to certainly be growing due to the decision of the Supreme Court in XX, handed down in 2020, where the court held that the cost of commercial surrogacy can be claimed where the claimant is using her own eggs and surrogate eggs. But think about the situation where the claimant seeks to use surrogate eggs and donor sperm. That is different, and it does bring into question the Human Fertilization and Embryology Act 2008. For a surrogacy arrangement to be subject to a parental order, there must be a biological connection. So there is a distinction, importantly, between instances where there is a connection to the claimant or the claimant's partner and a case where there is no connection at all donor eggs and donor sperm, you'd have to question the willingness of the family court to grant the parental orders and whether or not it's in the best interest of the child. So that's an interesting area that I'm sure will be subject of litigation going forward. So just a few concluding thoughts on this area. I've included the well-known passage from Lord Hoffman's decision in the South Australia asset management case, the famous example of the mountaineer. And it's worth reviewing this in full. A mountaineer about to undertake a difficult climb is concerned about the fitness of his knee. He goes to the doctor, who negligently makes a superficial examination and pronounces the knee fit. The climber goes on the expedition, which he would not have undertaken if the doctor had told him the true state of his knee. He suffers an injury which is an entirely foreseeable consequence of mountaineering, but has nothing to do with his knee. On the Court of Appeal's principle, the doctor is responsible for the injury suffered by the mountaineer because it is damage which would not have occurred if he had been given correct information about his knee. He would not have gone on the expedition and would not have suffered no injury. On what I have suggested is the more usual principle, the doctor is not liable. The injury has not been caused by the doctor's bad advice, because it would have occurred even if the advice had been correct. So again, it comes back to what I was saying about, is there an over-reliance on factual causation? Should the court be more willing to look at the scope of the clinician's duty and the loss which is being claimed, as Lord Hoffman suggested in South Australia management? Again, coming back to the surrogacy claims, you're looking at injuries for claims for compensation for the injuries suffered versus a duty to ensure that the claimant can carry a child. These are difficult questions to be answered, but if there is an over-reliance on factual causation, it will serve to diminish effectively the extent of the clinician's duty as relates to that patient. So I think that there will be a increasing number of battles on this between claimant and defendant lawyers, as the claimants will seek to say that the loss claimed is factually caused by the negligence. But I think that there will be pushback increasingly by defendants to say that there should be a slightly more holistic approach to look at the extent of the duty owed and how that interrelates to the loss claimed. And that's an interesting argument, because it's going back to some more fundamental principles of tort law, which we've examined in this webinar, certainly remoteness and foreseeability. So thank you very much.